Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today we are talking about modern families. We are seeing a very different society to the one that we might have seen previously, and I think it's fair to say that lawyers have to adapt and change and look at how their services reflect that society, if not quite the law. It's part of the discussion today that the law doesn't quite keep up with where we're at. I have Lucy Birch and Laura Tanguay with me, Birketts LLP. Lucy is a senior associate in the family team, and quite uniquely for the purposes of today's discussion, Laura is a legal director in the property disputes team. And Laura, you're going to explain to start with why that's quite important in the context of the Modern Families service that Birketts have launched and this discussion.
Hi David, thank you so much first for having us both. Yes, delighted to speak to you today about our Modern Families service and our specialist home ownerships disputes team, which I head here at Birketts. So as you rightly say, we do things a bit differently here at Birketts, and we decided a long time ago that we could serve our clients better if we housed our Trusts of Land and Appointment of Trustees Act TOLATA disputes within our property disputes team instead of our family team. And that makes sense for so many reasons, David, not least because these cases aren't heard in the family courts and they're tried under the civil procedure rules rather than the family procedure rules, to name a couple of reasons right off the bat.
Thank you so much for that introduction, Laura. Lucy, who are you? What do you do?
So I am a family lawyer. So I advise clients on all matters relating to relationship breakdown. So divorcing couples, financial matters as a result of the divorce, prenuptial agreements, postnuptial agreements, and children disputes as well. But I do have a particular specialism in private adoption law. So I advise families on how to obtain an adoption order, be that step parents, private foster carers or special guardians. And these cases can often have an international element. So that's where my specialism lies. But I do practice in all areas of family law currently.
Well, thank you both for the introductions. We're talking at a point in time where Birketts have launched a Modern Families service. And as you say, Laura, sort of born out of this change in society and really serving your clients better. I guess, Lucy, in the first instance, could you tell us about how a Modern Families service is different from perhaps a traditional, in inverted commas, family practice?
Starting with why we launched the service was because we recognise that the growing numbers of non-traditional families and how they can take many forms nowadays, and the days of having sort of the traditional 2.4 children within a family has completely changed. We at Birketts therefore decided to launch the Modern Families team, which contains a team of lawyers across multiple disciplines. So effectively, we can provide a sort of one-stop shop for all areas of various law which can touch upon modern families issues in one place. So we have lawyers from our immigration team, private client team, employment teams, and importantly, the family team as well, who sort of deal with a full spectrum of sort of modern families issues that can arise out of the family law arena, such as adoption, surrogacy, donor conception. There's a plethora of different areas that it touches upon. So we at Birketts, are really, really proud to launch this service where you can get all of those disciplines in one place, which I think does set us apart from those traditional family practices.
There's almost a collaborative element of this, isn't there? And that's a direction of travel for family services. Laura, you're coming into the team with a slightly different set of expertise and experiences, and aiming, I guess, therefore, to lend that to whatever matter is being dealt with.
That's right, David. And in many respects, we see in society as well a trend towards cohabiting couples. People are getting married less often. What happens when those unmarried relationships end? Generally, there's still a lot of misinformation and lack of understanding amongst the public about what their rights or lack thereof are, for example, in relation to financial and property affairs at the end of an unmarried relationship. We specialise in kind of getting to the nitty-gritty of this complicated regime under TOLATA, coupled with significant case law. And so that's very much complementing our modern family service, so that we can act for you in your separation, no matter whether you're married or unmarried.
I often think about the fact that the law simply hasn't kept up with societal change. And the challenge is that even now, whatever we bring to the statute may well be out of date very quickly thereafter. How much of a challenge is that for modern family practitioners?
A change to the TOLATA regime has been on the books sort of loosely for a very long time. There was a line about changing the law in this area in the Labour government's manifesto. I suspect they've got bigger fish to fry at the moment, so I'm not anticipating reform in this area anytime soon. But the Labour Party were at least correct in identifying this as a pressing area where we need reform to protect. They said women, but of course it applies no matter who you are. But more traditionally, I suppose it has been something that affects women more generally when they perhaps stay at home to look after children, for instance, and that might mean that they don't contribute towards the mortgage or other things, and that might have implications for them under TOLATA that they hadn't readily understood. Quite how any reform would take place is very much an unknown at the moment. When we have other jurisdictions that we can look at, and no doubt the government will be doing so when deciding what might work well, there's going to need to be some sort of criteria. Perhaps how long have you been in a cohabiting relationship for? In other jurisdictions, that period shortens if there are children of the relationship, for example. So there's lots of different ways to do it. And importantly, I think there will also probably be a way to contract out of any automatic legislative regime, probably by entering into a cohabitation agreement.
I was renewing my car insurance recently. On one of the big comparison websites, under marital status, it still says common law spouse. I can see you both shaking your heads in disgust. While multinational organizations are continuing to perpetuate that myth, we're going to struggle, aren't we, Lucy?
Oh, absolutely. It's incredibly frustrating. And, in my practice, I regularly see clients who have children and are married. When there are issues in relation to the arrangements for children, we work through that, but we also work through the financial side of support for families when they're separating and they've got children and they're unmarried. And there is such a lack of understanding a lot of the time, even now, in terms of what people's rights are. And, I see clients who have been living together for 25 years, have children together, and they just have a complete misunderstanding of what their legal rights are. And there are certain claims that can actually be brought under the Children Act if you're unmarried for financial support, in addition to the property ownership side of things that Laura's team deals with. And that's an absolute, it's not a straightforward piece of legislation. It's difficult to navigate, and it may well be that you sometimes could potentially have two sets of claims under different sets of legislation in different courts, which can sometimes be, so it really can just be so confusing to someone. So I do genuinely believe that we are crying out for reform in so many areas of the law, but in particular, cohabitation is just the area where we desperately need that reform. I think I read a statistic the other day that a cohabiting family is the most common type of modern family nowadays, and the law just is so desperately out of date. It's really frustrating as practitioners to describe it to clients, and it's just not fit for purpose, quite frankly. And talking about sort of legislation, just as a point of reference, the divorce laws that we use when we're talking about sorting out finances when a party is going through divorce are dated. It's the Matrimonial Causes Act, and they're dated in 1973, and that's the law that we're practicing today. So I think the law is always out of date, quite frankly, because of how long it takes to enact laws in this country, David. It's frustrating, but I think any reform is just desperately needed.
I don't seem to be able to talk to practitioners at the moment without cohab coming up, of course. What would you both like to see? And you come at it from two very different angles, I suppose, so it could be an interesting answer, this one. What would you both like to see happen, change, be enacted, reformed around cohabitation? I mean, in the first instance, I guess we probably want something that says cohab, don't we, rather than this mishmash of different legislation that you've alluded to, Lucy.
Yeah, that's absolutely right. So an obvious place would be to give some property rights to unmarried couples upon their separation. So it doesn't necessarily matter as much in whose name the property is bought, especially when they're pooling finances generally. So what we see today is if it's a sole name property, then the non-owning cohabitant has to be investing into the deposit to buy the property or to mortgage payments. Almost always that's what you need, sometimes in lesser cases to capital improvements to the property, but the case law is more unclear there. So it's quite a high threshold, and couples might be choosing to share their the financial strains of everyday living in different ways. Like one person might be paying groceries and council tax and utilities and all the other things that we have to pay for, and not necessarily the mortgage, but that comes back to bite them later on, and that's unfair. So some perhaps automatic protections that apply to a cohabiting couple that are in a committed relationship, and the government's going to need to decide what that looks like. Is a cohabiting relationship something that has lasted a minimum of 5 years, for example? I mean, this is a bit arbitrary and it's going to be difficult, but particularly where there are children involved, to me that really does sort of up the seriousness and commitment of the relationship. I suppose when we're met with those circumstances, I think it's only right that we provide more fairly for both parties when they separate, even if they have decided not to marry for whatever reason.
One of the things I would like to see is that the ability for cohabitees to potentially apply for maintenance as well, because I often see economic disadvantages as a result of a relationship. So one party, for example, might have given up work for a period of time to look after the children, and currently under the law as it currently stands, there's no real protection like a married couple would have in that situation to compensate that disadvantaged party. So maintenance in itself is a very difficult, very fact specific thing to advise on generally, but I think that's something that I would in particular like to see if in any particular reform. And I also think some entitlement under the intestacy rules as well would be something important to consider for cohabitees, in addition to sort of the exemption from inheritance tax, just like married couples. I think all these sorts of things, I think personally, would be useful when it comes to reform.
Listeners may very well be aware that today's media publishes today's Family Lawyer as well as today's Wills and Probate and today's Conveyancer. No prizes for guessing who we serve with the other publications, but each of those have their own imperatives around what they need and want to see happen in terms of reform and change. And Laura, you've said that you think it's unlikely cohab reform is going to come forward in this Parliament. I'm afraid I'm in the same boat. I suspect that there are other things that will happen. What can we be doing right now as practitioners to protect people that are coming into our offices who are perhaps purchasing a property as a first-time buyer with a partner? We know that about 1 in 3 first-time buyer transactions are cohabitee relationships. How can we be protecting them when they're coming into our offices right now?
So first, we need to make sure that our conveyancers are really clued up on the differences between joint tenants and tenants in common, and not just insofar as it relates to what happens if one of them should die. Because so often I see this advice given in the context of inheritance effectively, rather than what should happen if you should separate and want to sell the property while both of you are still alive, because not enough thought is given to that. And unfortunately, I've also seen examples where, say, one person has a property with a lot of equity in it, they hold it in their sole name, and then they decide to remortgage, and for the purpose of the remortgage, their partner is going to be a party to that mortgage, and so goes on the deeds to the property as a requirement of the lender. Now, I've seen that in a number of examples where they've actually gone on as joint tenants, and so all of that pre-existing equity is now effectively shared between the two of them from that point onwards. And I think if you'd spoken to them at the time and said, let's be clear about this, is that what you're intending to do? And this will be the consequence of that. If you split up the next day, this is what your respective shares would be. I think most people would say, oh gosh, no, that isn't actually what I'm intending to do. So there's a big problem at that point, at the point of purchasing the property. There's also a real lack of demand for cohabitation agreements at the moment. I think it's just not part of our DNA presently. Prenups are becoming more popular. They're very popular over in the States. They're becoming increasingly popular here. There's a growing awareness and recognition of them. Cohabitation agreements is like a step behind that. Buying a property is so expensive as it is anyway, and I understand that people don't want to be adding to the costs by entering into potentially an unnecessary legal agreement. And of course, there's a positivity bias here that everyone thinks that their relationship isn't going to be the one that ends. But really, people need to be taking this protective measure at the beginning, having that difficult maybe, but frank and open and honest conversation with each other and saying, yes, we love each other. Yes, we think this relationship will last the test of time. But just in case it doesn't, what do we want? What do we think is fair for each of us to get out of this? Should there be a right of preemption, allowing one of us to buy the other out, for example? Or would we prefer that it be an automatic sale on the open market to a third party? What will our shares be in it? How will we account for any improvements that we make to the property, and how will we fund those, etc. and etc.?
What you said there, Laura, to me, eminently sensible, but there is this lack of cross-pollination, I think, in law firms, and perhaps it's something that Birketts are getting right, but teams not particularly educating one another about the opportunities and the threats, if you like, between the different disciplines. Lucy, that's something that it sounds, as I say, as though Birketts are getting right. How have you adopted that? How have you implemented that? What can listeners to this podcast take away from it that you're doing that perhaps others aren't?
So at Birketts, we work very closely with other teams. So we actually have internal seminars and things like that. So Laura's team will say, right, when we get a new client, this is how we're going to deal with a client who potentially has Children Act issues and also issues relating to property ownership. So we often have seminars across teams, so we're keeping up to date with the latest developments in their respective areas, so we're aware of it when we're giving initial advice. We sometimes will have joint meetings, so we'll have a specialist from a family team and also a specialist from Laura's team, so we can give clients that specialist advice at the earliest opportunity, so they're getting the benefit from both teams. So I think that's how we try and keep things as relevant as possible at Birketts, and everyone's up to date with each other's areas of law and developments that are going on. I think that's something that does set us apart. We work very collaboratively, even though we're sitting in different offices. We often have teams working within the same office as us, and we'll wander over and ask questions. So we do have a very collaborative environment, which I think is reflected in the Modern Family Service itself, because we have so many different areas working together for the benefits of clients.
Is that done in person? Is it done on Zoom, Teams?
It's a mixture.
Most of this stuff these days.
Yeah, it's a real mixture. So a lot of the time we do really focus on doing things in person where we can, because we think that's important. But we often have meetings on Teams as well. It's a real mixture of the two, to be honest.
So there's, I suppose, an education piece there, David, generally, and we work very closely with the family team to, help both of us understand where each of us can help our clients. And that's something that is quite unique to Birketts, I think, because my opponents are family lawyers. Often the correspondence I receive is aimed at, seeking an outcome that doesn't necessarily reflect the outcome that you're likely to get at court. And that's, I don't know, perhaps it's just the family style or perhaps lack of understanding of the relevant legal principles. I'm not sure. But the other piece, going back to what I was saying about the conveyancing being an interesting pinch point for these problems, we at Birketts have also worked closely with our conveyancing colleagues. So, for example, I personally reviewed all of the advice that we were giving to our clients at the point of purchase to make sure what we were saying about joint tenancy versus tenancy in common said what it absolutely needed to say. And then I also made a YouTube video with a link that's embedded into that guidance document so that the clients are getting that information in another way, and potentially a more accessible way, because these are quite complicated topics and not helped by these kind of legal jargonistic terms of tenancy in common, and your average person doesn't necessarily appreciate what they're signing up for there. So we're giving that information to our clients as clearly as we can.
I've worked in many different law firms. Often you will get family lawyers who do all the TOLATA work, and I think it's a very different skill set and it's a very different mindset. So the civil procedure rules firstly are very different from the family procedure rules, and I think you have a completely different outlook on a case. As family lawyers, when we're looking at resolving financial matters, we're looking at the parties' needs, and our focus is very different to what Laura's team will be looking at, because their focus is completely different and they look at it with a completely different mindset. And I think having a specialist team of property litigation lawyers looking at these kinds of disputes is so helpful. So when I joined Birketts last year, when I learned they had a specialist team for that sort of work, I was overjoyed, because it is so alien to what we are trained to do as family lawyers. It's incredibly helpful, and in particular, the clients benefit from that because they're absolute specialists in what they do.
I'm an absolutely huge believer that there is not enough education about the law in life, and I mean it starts at grassroots. And don't even get me started on education, because kids come out of school without the ability to open bank accounts, never mind understand the law. So that's not a debate for now, but I absolutely see that there is not enough education around this. I guess the barrier to a lot of people is cost. Is that something that you guys find?
People can perhaps not want to pay for a cohabitation agreement for that reason, because they're already having to incur stamp duty, land tax and all sorts of other things, and there's this positivity bias that makes them think it's not necessary. However, that expense will save probably a lot of money in the long run should they need it. And the clients that come to me, unfortunately, are between a rock and a hard place, because they haven't got any other good options. There was an article on the BBC only the other month about financial abuse. It was titled something like "I'm trapped in a mortgage with my ex," and this poor woman was she had a joint property with her ex, joint mortgage, and her ex had moved out and effectively stopped making any payments towards the mortgage and then wouldn't agree to sell the property. So she was suddenly saddled with the mortgage payments each month, which she couldn't really afford. It was damaging her credit rating, and she wanted to sell, but he was sort of holding her captive in that situation as a way to kind of exert control over her. In that situation, she has no option but to see a lawyer, to go to court to get an order for sale. And yes, that costs money, but that's, you can't force someone to sell a property. Only court can force you to sell a property. And likewise with equitable disputes, although you need the cash flow to be able to fund them, unless there's an insurance option available for you, or perhaps a CFA or no win no fee or something arrangement that the firm's willing to enter into, you're having to spend tens of thousands of pounds. But it might be worth it, or proportionate or commercial, to do that, because there might be hundreds of thousands of pounds at stake in the property that you're fighting over. And again, in that situation, what are your options? Simply to walk away and accept that you'll never get any of that interest.
What we're seeing here is an even greater specialization within family law, I think, and it's so important that practitioners invest in themselves, invest in their own understanding, in my view, and clearly in your view too. I mean, we've talked extensively about cohabitation here, but I know, for example, that you've got a pretty active surrogacy practice. That's another area of the law that is in desperate need of reform?
It absolutely is, David. So, the law on surrogacy, again, it mainly dates back to the 1980s. And I think since then, I think I read a statistic the other day that surrogacies have quadrupled in the last 10 years. So there is, ever-increasing demand. But unfortunately, surrogacy laws have just completely failed to keep pace with it. The Law Commission did actually publish a report in 2023 and outlined a new regulatory regime with various recommendations to introduce more clarity, more safeguards and support for intended parents, surrogates and children, because the aim is to have a well-regulated domestic surrogacy regime that works in the best interests of all involved, similar to regimes that exist in various other countries. America, for example, is a really popular destination for international surrogates for lots of reasons, and I think the law in the UK is just crying out for reform, because and the law as it currently stands, the child has to be born, it has to be at least 6 weeks old before you can actually make an application to the court for a parental order. And that process in itself can take up to a year. You could be left in a situation practically where you don't have parental responsibility for a child, and you're not able to make significant decisions in relation to the child's life, which is just completely unfit for purpose. So we desperately need the reform, but unfortunately, like so many other laws in this country, I don't necessarily think that's going to happen anytime soon.
Perhaps the best we can do for the time being is to really drill into our own experience and expertise, as I say, understand what we can and bring in that wider experience where we need it. It's been great to have you both on the podcast, and I'm hugely appreciative of your input and insight, and really interested to understand how your firm is utilizing the wider experience of the business to best effect. Thank you so much for joining the podcast.
Thank you for having us, David.
Thank you.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on today'sfamilylawyer.co.uk. My thanks to Laura and to Lucy. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at today'sfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.